Game begin.
Well, hello everybody to our little presentation on some aspects of German employment and civil law, freelancer law. So, what do we want to look into today? The first topic is freelancer versus employee. So, what is the difference? What are the differences? And what is a freelancer? What is an employee? We will have a look at that. Afterwards, we are looking into limited term employment because we know that many of you are faced with such contracts or will be faced if you're entering into a new employment relationship. And the same goes with the probation period. So what does this mean, probation period, and what are my rights as an employee? And in the end, we will have a look at incentives which may be offered to you with the new job or may not be offered. So we might give you some ideas which incentives you may ask for when you want to join a new club. All right, let's have a first look at what is a freelancer or freier Mitarbeiter in German. Well, generally speaking, basically, a freelancer is a one-person enterprise. So the freelancer goes out into the market and cries out, "Take my services, sign me up, I want to work for you." The freelancer works with his own equipment. Typically, he or she has an own office space or works from his or her home. Some of them, if you're big enough, you might have your own employees or subcontractors, and you're always working on your own financial risk. So you are out there in the market and being an entrepreneur. So in fact, like a limited company, GmbH or whatever, but without this company structure, this company structure around you. It's a one-person show. So this is the typical freelancer, right? Now, sometimes freelancers also work within the company of the contractor. So you visit, let's say, the games company which signed you in order to make some programs. So if you're visiting and if you are still your own boss, not receiving directions from the games, from your contractor, then it's fine. Then you're still a one-person entrepreneur. You are your own boss, and you keep staying a freelancer.
Yeah.
If you are involved too densely, too intensely with the shop and the structure of the contractor, you might switch over becoming an employee. Kai, you were
Felix,
about to say something.
yeah, maybe we just point out what the actual difference for the persons are, for the employees or freelancers, because that is also a thing of major importance. Many people believe that being a freelancer is something they want to be because they have some freedom, and there is something about social payments or so. Well, the main the main issue is that as a freelancer, as Felix said, you're an entrepreneur, which means that you yourself have to take care of your social security, which means you have to take care of your health insurance, you have to take care of your own pension insurance, you have to take care um, of your own unemployment insurance, or any investments that you take aside for cases of unemployment. So there's no traditional social security for you, as many of you may know it from being an employee. On the one hand, that's nice because you don't have to pay for that. So you can keep more of the money that you receive. On the other hand, there is the downside that you don't have these social nets that are installed for employees, and if they become ill, if they are become unemployed, you will not get Arbeitslosengeld, so unemployment.
Benefit.
Yeah, so, unemployment benefits from the state in case there is no one who gives you a new contract. So the main difference is, as a freelancer, you might keep more of the money, but you have no social security. You have no backup net that catches you if there's no one who's hiring your services. And that's also very important to understand, because if we make this differentiation, as Felix started right now, between a freelancer and an employee, it's not just the question if you can be fired or not, but it's also a question of taxation. It's a question of social security payments, and it's a question of social security benefits that might be related there too. Also, many legal terms that are in place for employees will not apply to you. For instance, limitations regarding work time, they only apply to employees but not to freelancers. So there's a lot of social protection that you're giving up by being a freelancer. However, on the other side, you might have more money in the end. Sorry, I just wanted to throw it in here so that people will understand why we're discussing that, actually.
Absolutely. So let's have a look at the next slide and switch over to employees. Now, the typical thing about employees is that they do have to do what the employer is telling them to do. Receiving, so if you receive an order or a directive, um, you'd better accomplish your work according to this directive. Whereas a freelancer is free to say, well, you want me to do it this way or that way, but I do it my own way, and that's why you're booking me. So this is the real and crucial difference between freelancer and employee. Um, Now, as Kai said, employees, they are covered by the social security system. Um, the employer even deducts the income tax from the employee's salary and sends it straight away to the tax authorities. So, in fact, you don't have to do anything. You don't have to care about anything as an employee, because everything will be done for you by the employer and by the social security systems. And all of the laws, of the employment laws, apply to you, whereas freelancers cannot claim any rights from any statutes, regulations concerning employees. They are free and not protected by those regulations. So where are we now? Um, we are looking into limited term employments. Well, sometimes, and I guess seldomly, you will be offered an unlimited employment agreement, meaning that you start to work, and unless you quit the job or you get you get a termination by the employer, um, this employment agreement will go on and on and on. Well, typically, especially if you're new in a job, the employer wants you for a limited term, perhaps also for a project. So this is the third bullet point. Um, and projects, most of the employment agreements are limited because the employer does not know if you will get a new project and if you will fit to the new project and if you can work on this project. So that's the one thing. The other reason for a term for limitation can be only time. So your employment agreement can be limited for up to maximum 2 years and 3 times. So, for example, 6 months, another six, another, and a fourth 6 months, and that's it. Um, and those will be justified limitations. Um, Still, if you have the idea that your employer did something wrong with the limitation, you could check with the lawyer and even go to court when your limited term employment agreement will end in order to fight for an unlimited employment agreement. And this can work out if the employer did something wrong in the hiring process. For example, um, letting you sign the employment agreement via PDF on a PDF, or send you an email and you agree via email or WhatsApp, Twitter, whatever. All this is not a valid limitation to an employment agreement and can be tackled before court. Kai, do you have a comment to that?
Yeah, just one thing that's really interesting because yesterday we've received the new coalition agreement for the new German government, and they decided on some issues that may also touch on this issue of time limited contracts. For instance, the limitation for projects will also receive a timely maximum limitation of 6 years. So while right now, if you have a project limitation, you can continue that without any limitation. The coalition agreed yesterday to have a limitation for project limitations of up to 6 years.
Right, so just another headache for the employers, and it might be a benefit to you. Now, let's have a look at the probation period. What does that
Yeah.
mean? Well,
Just
first
just
of all,
just one
yeah,
other
please,
thing
please.
to add because we've just been there. If you're working on a games project, it's often quite complicated to find out when the project actually ends. Because does the project end when the game is released, or does it end when the game uh, is no more supported by the developer, or if there's no further content development? So when is a project finished? That is something that is still quite controversial, at least for time limitation due to an individual project. So this may be something that you also have a look at. When does the project actually end? Does it end when it's released? Does it end when no more content is produced? Does it end when you are no more required to work on the project, which could also be at some stage? For instance, there might be no more requirement for a level designer on a project, even though the project is not released. Yeah. So this is also quite complicated how this would actually work and when you would when your limitation would end. And Felix, as far as I remember, if you continue working even though the limitation has actually ended, then you automatically switch into an unlimited contract, right?
That's correct. You can slip over, and in fact, you made a very good point. Thanks, Kai, with the project limitations, because if you are in such a project limitation limited employment agreement now, um, please note that if the project is finished, your employment agreement is not automatically finished. You still need a something in writing by your employer telling you the exact date on which your employment agreement will end. And if you do not receive such a message, which can in fact also be via email, it does not have to be written on a piece of paper. If you did not or do not will not receive such a notice concerning a date, your salary will you're entitled to receive your salary still. So this is really a trap, and this is really well, something employers do have to be aware of. Some are not. Some are not. Well, let's jump to the probation period. If you start a new job, um, as an employee, of course, not as a freelancer, because this only applies to employees. The first 6 months, you will not be covered by or protected by the Act Against Unfair Dismissals, the Kündigungsschutzgesetz. So within the first 6 months, it's hire and fire, and the employer can set you free for any reason. He or she might state that they are not content with your work, with your attitude, whatever. Um,
Any reason or no reason at all. That they don't even need to state a reason.
yeah, yeah. In fact, that's right. And sometimes additionally, your employment agreement, or typically, it contains a short notice period within those first 6 months of 2 weeks. So, in fact, this is really, really hard if your employment agreement is terminated within the probation period of the 6 months. You're out within 14 days. So, if your employer comes up and with the idea of sacking you within the first 6 months, I think it's always worthwhile to negotiate and ask if it's not
Mhm.
possible to set you free with a longer notice period, because this is possible. The employer, and in fact, I counsel, I advise many times, I already advised employers to be more social and give you an extra probation time by terminating the employment agreement, let's say after 5.5 months, but with a notice period of 1 or 2 or 3 months. So then you will be out. That's guaranteed, because there's no way you can challenge a termination within the probation period unless there's a formal mistake. You see the bullet points, right? But except from this, you cannot challenge this before court. It's useless. You will lose money. Um, but you will gain time, and you will be employed not only for 5.5 months or 4 months, but for a longer period, like 7, 8, 9 months. And it doesn't look like as if you were sacked within the probation period. So I think this is a really good thing. If you find out where something goes wrong, the chemistry is not fine, it goes against me, the employer wants to get rid of me, try to negotiate this way, which I just showed you now. And yeah, good luck with that, because I think it's employers should always do this.
Yeah, and also if you're able to negotiate your first or your next employment agreement, reducing the probation period is the one thing that might be more important than a higher salary in the beginning. So if you're able to reduce or even get rid of a probation period, that might be much more worthwhile than maybe $100 more a month. So um, when you're negotiating contracts, keep that in mind. That may be more important to you than many other terms.
Absolutely. And then there's another advice. Now, if you are already well senior or with experience, and
Mhm.
you change employer and sign up with a new company, you may really try and negotiate that the Act Against Unfair Dismissal will apply from the first day on
Yeah,
without a probation period, right? Because you already showed that you're good and that you're worth your money. So this is also a possibility, and you may go for this and succeed. Now let's jump to our last slide, showing which incentives may be offered by employers and are typical, right? So many employers offer like payment for public transport or a company bike, well, and traditionally a company car, but in the games industry, and well, also modern employers, they really rarely offer cars, right? And who wants that? At least in cities, right? Now there's
yeah.
also
Most often,
lunch.
even the CEO doesn't have a car. So asking
Yeah,
for a company car if the CEO doesn't have one, that might get you stranded in the negotiations.
absolutely. So you should do some research before you're asking for a company car. And in fact, I don't have a car either, and I can completely sympathize with this new move towards public transport and bikes. So lunch subsidy, you may ask for lunch subsidies if the employer does not offer it from by himself. Um, if you're moving places, um, you might ask for some money to move your stuff, your furniture, and everything. Um,
Yeah,
there
especially when
might
you're
be
moving
company.
internationally, that's really standard.
Yeah, international. You're right, Kai. It's really standard. If you're moving from abroad to Germany or the other way around, it's really standard to get some money for that. A company pension plan might be installed. And then, of course, some companies do offer stock option programs. And it's always nice to be part of that, because if the jackpot is hit, you can make quite a lot of money. Kai, what do you say to that?
Yeah, maybe I'll add something because stock options are a little bit different here in Germany than many people are used to. For instance, abroad or in countries like England, that is based on common law. Here in Germany and also in Austria, it is so that granting someone shares on a limited liability company is something that is really complicated because each and every time you want to grant someone shares, you have to visit the notary and have it notarized. This is, on the one hand, complicated and costly. And if you are supposed to be part of a share option program and you get shares each month, then the CEO will be busy just notarizing share options for his
Mm,
employees every month. So that's something that usually does not work here in Germany. So what we what we came of here, and which is standard and which is quite often used in games companies too are so-called virtual share options. In such virtual share options, you will not become an actual shareholder of the company, so you will not be an owner of the company, but you will be treated as if you were a shareholder in two cases usually. And one case is the company makes profit. So your game is successful. You get a lot of revenue share as a developer. So you're profitable as a developer, and the developer and your employee decide your employer decides to pay out profits to shareholders. In that case, you'll be treated as if you were a shareholder. So you will also receive, as a bonus payment in your employment contract, a certain bonus payment in an amount as if you were a shareholder to the amount according to your share option plan. So it usually depends on how long you're with the company, and you'll be able to gain a certain percentage of virtual shares, and that will be the basic for calculating your profit margin. The second case where a virtual shareholder is usually receiving payments is an exit scenario. So it's not that uncommon since 2 years that a German developer is actually purchased by an external publisher. We've seen a lot of such purchases in the last 2 years, and in that case, the shareholders usually receive quite a interesting amount of money from the publisher who purchases the development entity. And also in that case, in that exit case, also employees are treated. Those employees who have share options are treated as if they were a shareholder, and they will receive part of the purchase price that is paid to the original founders of the company. That might be a quite significant amount. Um, um, that will be fully taxable, by the way. Yeah. So you'll have to pay tax and social security on that. But still, it is something that is quite a good option for employees to stay with the company. And um, also important to understand is um, usually you lose your options once you leave the company. So in most cases, you're only entitled to these payments as long as you stick with the company.
Yeah, great.
Yeah.
So, in fact, this is the end of our presentation, and we are happy to answer your questions.
Yeah, thank you for this nice live talk. And we stay in English here because we have an English question from
Oh,
P. Sartre. What if I'm an employee as a game designer but never got an order task by my boss on what I have to work? Now I start working on the game because I think my boss wants to do that. My who owns the done work, graphics, sounds, music? Did I have the right to use it? Use the stuff for applications?
Okay, so I understand that this is a question concerning intellectual property
Yeah,
on
mhm.
the work results. Is that correct?
That's correct. I think. Yeah.
Yeah. Well,
Okay, what you want
usually
to?
as yeah, sure. Usually, as long as you do it within your work time and within the scope of the work that is done in the company, everything you do is owned by the company. Um, if there's something you're doing privately at home, that might be different as long as it has no connection to your actual work. Yeah, if it has a connection to your actual work, then that might also be owned by the company. But if it's totally independent, that's fine. But please be careful. Um, Doing private projects is something that is often excluded in employment agreements. So usually you require the permission of your employer if you intend to do private projects and even commercial private projects alongside your normal work. Most employers will grant you the permission as long as it's really private and you do not start publishing it and earning money with it. But once you do, you start a commercial business out of that. Many employers will not be so happy about that. So basically, what you do is, in most cases, owned by the company. What was the second part of the question again?
The second part of the question is what if I'm an employee as a games designer but never got an order task by my boss on what I have to work? That was the first of the second questions.
Okay.
And now I start working a game because I think my boss wants that. So
Yeah, well, if you do it as part of your employment, it's owned by the company.
okay.
Yeah, and the order task, an employer does not have to hand out a written order task to employees. I mean, normally, usually, the employment agreement qualifies your job. This might also be broad, like developer or software engineer or whatever.
Okay.
And then the nitty gritty and the daily work, this is up to the employer, and he or she decides what, in fact, you are actually doing on day 1, day 2, day 3.
Okay. So, dann switchen wir mal wieder auf Deutsch zurück. Also vielen lieben Dank auf jeden Fall für dieses sehr, sehr interessante Gespräch. Hat mal wieder eine ganze Menge aufgeklärt, gerade in dem etwas komplizierteren deutschen Arbeitsmarkt, denke ich. Und ich bedanke mich ganz lieb und hoffe, ihr habt auf jeden Fall noch einen schönen Tag und wünsche noch einen schönen Restwoche.
Alles Gute. Bleibt
Danke,
gesund.
ciao.